their draft order.
Yes, and naturally I will have to give direction. There may well be a need for the filing of further affidavits,
Yes.
because there would be a change in the circumstances
There may.
from today
Yes,
until
of course. We'll need to
when the
update
matter
it.
next serves before.
Of course.
Yes,
So we'll put that in as well.
yes.
So, Milady, would you wish to receive the agreement? Do we have a copy?
Sorry, do you have something to say?
No, I'm sorry, we can.
What I'm told is it can be uploaded on the case lines.
But I would appreciate a copy, please. Thank
We
you.
have it available. So before I address your ladyship, perhaps we can hear from the various counsel as to where their positions are.
Yes, but I also needed to hear our litigant in person.
Yes. Mr. Hulett, I understand, wants to address you.
Yes, yes. So before I hear from any of the counsel, sorry, he seems to have left. Well, maybe he will reappear. Okay. May I hear then from?
Yeah, we've kind of agreed on an order subject to you that Vision should address you, the Vision party. So my lady, I can confirm.
So sorry, will you be addressing?
I'll be
on
Vision
behalf of
of both Visions.
Yes.
Double Vision.
Yes. Double Vision, thank
Yes.
you.
Ma-
It helps.
Unless Mr. Ramachale can always add something that I've missed.
Yes.
I'm not taking away from him. But
Yes.
our position
Thank
is the
you.
following, lady. As you're aware of the dynamic, just so we can get it on the record, what this postponement does is, as Mr. Subel indicated, it gives the company an immediate lifeline until June. And as your ladyship has picked up from the papers immediately, the burning question ultimately is going to be what happens between now and June. Is the company's able to get over the reasons that leaving aside the correctness, are the practitioner going to be able to satisfy themselves and you by June that the company has now an alternative rescue possibility, call it a plan, whatever, given that the original plan on any version has
The
not
original
come
plan on any version
has
was
not come to
still born.
fruition. Yes.
Yes.
And so not still born. That's a different question. That's what RGS have to say. But that's a separate point.
Yes.
That's a separate point. The point is it's not capable of substantial implementation. That would be the test to get it out of business rescue.
Yes.
And so I'd just like to place a couple of things on record for Vision. Is firstly, so that the court will have to appreciate, as you say, there are obviously going to be dialogue between the same three parties and maybe anyone else who has an interest about what can be agreed to be put before creditors one way or another for an alternative rescue. And that will have to be told to the court by way of affidavits before June. And so that's why this is an interim position, but it doesn't represent any party having given a final commitment to anything, neither Vision nor the IDC. Vision just wants to record, my lady, that although it has consented, and a consent is a consent, it remains concerned on the basis of what he said in the affidavits, that despite these many months, there is not yet a proposal that includes the IDC or anybody else that provides a long-term rescue. In accordance with good governance and corporate governance, accepts that June, at least liquidation can be averted until June, but it is very concerned that the IDC have effectively advanced money at very high interest rates. It's added to the debt of the company, and none of this is going to be to anyone's benefit unless parties engage in order to actually come to an alternative type of rescue. Whether the first one was stillborn or not, we can have a separate debate. But unless this court can be given a viable plan going forward, I don't think we can keep on 3 monthly installments of PCF while the debt rises. Vision has to release security, and there's got to be an end in sight, and we're just putting all parties on notice that Vision's attitude is to accept the postponement, to accept that the PCF's coming in, but it's not a lasting solution.
Well, I understand
Thank
it's interim as you submitted.
Yes,
So
yes, it is
yes.
where we are. But we
Yes,
support,
thank you,
on that
Mr.
basis, we support the matter being postponed to June to see whether or not an alternative can be put up.
yes, I believe that what should happen is, no, sorry, Mr. Blow, I'm not addressing this.
I'm
to
sorry,
you.
yes, okay. Yeah.
Whichever council agrees with the position and aligns themselves to what has been submitted by Mr. Sobel and to a large extent by the vision parties, I'd like to hear from them. So maybe I should hear from Mr. Fine so long.
Just bear with me, ma'am.
Yes.
If I could just hear what my learned Jew is.
Yes,
Sorry.
certainly you may.
Could I suggest, my lady, that perhaps RCS addresses you and then I can address you then, if that's convenient?
Well, there's other players.
And the other...
Well, I'm simply asking who's consenting to this order,
Okay.
because I understand RGS's position is different.
Yes, we're consenting to the order. And I'm just hearing from my learned friend that, and I just want to firm up on that. I don't want to make any statement which is incorrect. We believe that the 200 million will last a little longer than the end of June. And if I may just take some finite instructions on that.
Yes, you may.
Yeah. In the answering affidavits, we had said that the management forecasts were sufficient to take it to October. That is not entirely, I think there is some dispute about that. We would prefer a little longer, but 2.5 months, we think the 200 million will last longer. I would press for a little longer in the circumstances. I think 2.5 months is going to be quite hectic, but there is obviously, we accept, milady, as all the parties have, that there is immediacy in relation to this issue, and the sooner it is resolved, the better. Our attitude.
Yes, thank you. Thank you, Mr. Fine. Mr. Van Rooyen?
Well, lady, from the growers' perspective, our position has always been that we want the mills to open as soon as possible.
Yes.
And although this is a very short runway that's been given, it's a funded runway. And our stance has always been that with funding, we believe the mills will open and the growers can start delivering their 3.8 million tonnes of cane and earn their living. So we do not oppose
Yes.
an adjournment of the matter.
Yes, thank
We
you,
would
Mr.
like a
Van
bit
Rooyen.
longer, but we go along with the RDC's view on
Yes, thank you.
Lady.
Yes.
Our position on the matter is the postponement would be a pragmatic approach to the situation, taking into account the position we take in our papers that the application actually ought not to be granted and the reasons we give therefore. But in the context of parties having had discussions and reached milestones that, you know, on any version, milady, happened in a matter of weeks, where over a few months they couldn't meet each other. The postponement would be helpful and could achieve an end that is meaningful to the parties. And that's the basis upon which we support the postponement.
Yes. Yes, thank you.
Support the
Mr. Allsworth? What is your position?
Lady, I think it would perhaps be best if I speak after Mr. Kotze, because I think a lot of what I might have to say would overlap with what he has to say, but he can probably address it in more detail than me.
Yes. Ms. Diodath, I assume that you also take the same position as Mr. Allsworth. You'd rather address the court after RGS has addressed him.
Certainly, Milady.
Yes.
Just to place on record that the position of Agrina, Milady, is that we will be opposing effectively the relief that they're seeking. We believe that effectively what they've now done is they've removed the substratum of the application itself. So to that extent, what should rightfully happen is the application should be withdrawn. And in the event that they form this opinion or the conclusion in the future, they can bring a fresh application. Maybe this matter cannot be remedied by the delivering of further affidavits, but I'll address that with the lady after my learned friend addresses the lady.
Yes. Yes, Mr. Kotze.
Lady, Lady, my learned friend, Mr. Subel, submitted that IGS, in opposing the postponement, seeks to revert to a position where there's no money. That is with respect incorrect. On the contrary, the IDC's condition for the extension of the PCF and the increase in the quantum of the PCF has always been that the company remain in business rescue and be kept out of liquidation. So there's nothing to my knowledge in the PCF agreement that has been circulated 5 minutes before this hearing commenced, and which I've not had an opportunity to study, that makes the PCF conditional on the postponement of this liquidation application or on the liquidation application being kept alive. So the provision of the PCF and the dismissal of the liquidation application are not mutually exclusive at all. Everything that the parties seek to achieve by further engagement can very well be achieved after this application has been dismissed. It seems to me that the that the postponement of the liquidation application is being sought as though it's there for the asking. There's no reason to postpone an application for the liquidation of a company, specifically not if brought under 1413 of the Act, if the applicants in that application cannot demonstrate on the extraordinary urgency on which they brought the application that there are grounds for the relief they seek at the hearing of that application. So quite plainly, the BRPs have not demonstrated a case for your ladyship to grant the provisional liquidation of Tongaat Hulett, and this is for the reasons that were set out in IGS's heads of argument prior to the extension of the PCF, but it is rendered completely beyond doubt now that an additional 200 million rand has become available, that there's absolutely no basis for the discretion or the decision that the BRPs have reached under Section 1413 to say that no reasonable prospect exists to rescue the company. Milady, the BRPs have no entitlement to keep, or Vision or the IDC, have no entitlement to keep the liquidation application and Tongaat Hulett in a state of suspended animation by postponing this urgent liquidation application for a period of a couple of months to see what happens. And before I proceed to develop that argument, I would point out that keeping a liquidation application in limbo is not without consequence. In terms of Section 348 of the 1973 Act, the winding up of a company by court is deemed to commence at the time of the presentation of the application for winding up, in this case, the 11th of February of this year. Secondly, in terms of Section 341 of the 1973 Act, any disposition of property by a company after winding up commences is void unless a court orders otherwise. So the effect of this, milady, to keep this application in limbo is that if the vision plan, well, there's two things. It's keeping this application in limbo and keeping the vision plan that has on the BRP's and the IDC's version failed, and that the minister has described as a perversion and abuse. Those two things together will mean that if vision doesn't come right in its shakedown of the IDC for the full extent of its funding under the plan, and if liquidation then ensues, the effect of that will be that the company will be deemed to have been liquidated on the 11th of February, every disposition made, every share pledged, every asset sold will be void. And to unscramble that proverbial omelette will be a nightmare, and there's simply no reason to risk that eventuality. And the simple answer is that the BRPs can launch an application under 141 when they have a case to make out the relief they seek. As they sit here today, they cannot both say under 1413 that they no longer believe there to be no prospects of the company being rescued, but also they want to keep the foot in the door on that discretion and see what happens over the next couple of months until the end of June, so that they can then just slide back in on the postponement and argue for liquidation. Milady, regardless of whether the court dismisses the liquidation application or whether it postpones it, I submit that the vision plan must be set aside. The BRPs and the IDC agree with RGS that the plan has failed in its execution, and that is after more than 3 years of rescue supervision. As I understand, Vision concedes, if not that the vision plan was stillborn, it does concede that the plan has now failed. And it is evident from the correspondence that Vision sent to the IDC, that is attached to the IDC supplementary affidavit as SA3, that Vision itself accepts that it will have to take whatever new proposal. In that letter, they detail a sequence, a whole slew.
Which letter are you referring to now?
So it's Annexure SA3 to the supplementary affidavit filed by the IDC. I'm afraid I don't have it on the record. I just have it as it was sent to me, because that's the affidavit that came in on, was it Sunday or Monday? But in that
Came in
letter,
on Tuesday, to be precise.
Tuesday. So, my lady, in that letter, Vision, so it's Annexure SA3, and it's a letter from Vision's attorneys to the BRP's attorneys on the 8th of April. And in that letter, your ladyship will see from in paragraph 4 and all its subparagraphs, Vision details all of the attempts it's made to interact with the IDC, and the fact that it has made more than one additional. So at paragraph 4.5.3, they refer to an initial proposal. Then in paragraph 4.5.7, they refer to an alternative proposal. Then they say that there were no responses. Then in paragraph 4.5.14, they say, our client has since made a further proposal to the BRPs on the 7th of April 2026. But what they do concede here as well is that, and this is at paragraph 4.5.7 of that letter, that our client also advanced an alternative proposal, including amendments to the plan for voting by THL's creditors. Now, that admission is an admission to the fact that the plan as it stands is incapable of implementation without an amendment. But, my lady, to move away from this and to move back into the realm of section 141.3 and the BRP's motion to postpone, on the authority of FABA, which I've provided to your ladyship in my heads of argument, the court held there unequivocally that a court's discretion under section 1413 of the Act does not extend to a discretion to extend a plan that has failed in its execution, and that any such extension would be contrary to the scheme of the Act. So what your ladyship has before the court today is a company that's been in rescue for more than 3 years, a plan that was adopted on the 11th of January 2024 that everybody concedes has failed in its execution. But the effect of simply postponing this application is contrary to the authority in FABA, and it's contrary to the SCA authorities that I will get to in a minute. But, my lady, it goes much deeper than that, because the minister has categorized correctly the plan and its implementation as an abuse and a perversion that cannot be allowed to continue. So, and further to that, the BRPs say in paragraphs 51 and 56 of their heads of argument, and I'd actually like to take a minute to go there. So in paragraph 51 of the
Just let me get there, Mr. Kotzer, please. Yes, you were referring me to paragraphs?
51 of the BRP's heads of argument, yes. Lady. So there they say, in response to one of the opposing parties' suggestion that the plan can be amended, the BRPs say there is no reasonable basis to believe that any amended plan will address, and this is important, they say it will not address the fundamental obstacles which have prevented implementation of the plan, namely the failure of Vision and the IDC to reach agreement on the terms of Vision funding and refinancing of PCF. So just before I explain the import of what that means, if we turn over the page to paragraph 56, the BRPs also say there that there's no reasonable basis to believe that a revised plan is capable of adoption or implementation in circumstances where the primary obstacle of the implementation is the failure of Vision and the IDC to reach agreement on funding terms, and Vision has demonstrated an unwillingness to cooperate with further processes absent its own demands being met. Now, we must, with respect, my lady, be very clear about what Vision is saying in response to this PCF. Granting 200 million rand in PCF does not at all address the fundamental obstacles to implementation that have been a scourge in THL's business rescue, because the fundamental obstacles are that Vision does not have funds to implement its own plan. When Vision argues that what they require from the IDC is a viable long-term solution, that should be translated into plain English to mean Vision wants the IDC not only to pay for the full implementation of Vision's own plan, but also to give Vision the working capital it needs to conduct Vision Sugar, its brand new company, with all of Tongaat's assets as its own. So where there's reference to a sustainable long-term solution from Vision, they are saying that Vision needs the IDC to cave to their demands, to fully fund them, to accept responsibility for the full refinancing of the PCF, and to give Vision a working capital facility. All of these things are in addition to the guarantee that the IDC has already given Vision and extends to an exposure for the IDC in excess of 5 billion rand. That is what they mean when they say we need a workable solution.
Yes.
So with all due respect, the idea that this 200 million rand stopgap, which is a godsend in terms of trying to save Tongaat in the short term, it must not be understood to address any of the fundamental problems to implementation that the BRPs have always said have become intractable, and which on Vision's own version, my lady, if I can, I don't need to take you there, but if I can refer your ladyship to the affidavit that Vision filed in response to the IDC supplementary affidavit. I mean, they say.
Sorry, are you now referring to an affidavit filed by Vision?
So Vision responded to the IDC's.
When was that?
On the 14th of April, it seems.
That would have been yesterday. I haven't
Yes.
seen that affidavit.
The day before yesterday. But my lady, your ladyship need not go there now. Your ladyship can read it whenever it is put before the court. But
If you are referring to it, Mr. Kotze,
yes,
surely I need to have a look at it.
yeah, if your ladyship has it.
Casper, where's our attorney?
I don't have a hard copy, otherwise I would have handed mine up to your ladyship, and I'm working from my laptop. Thank you, Adrian. Thank you. The attorney for the IDC is getting your ladyship a copy, which I'll hand up in a second.
Do we have a hard copy, please? The
Thank
system case lines is extremely slow.
Here's a hard copy, my lady, thanks to the IDC's attorney.
Yes, thank you.
So if your ladyship could turn to paragraph 12. So perhaps we can just quickly canter through the affidavit. It starts by, under the first heading of the IDC's proposed 200 million PCF increase at paragraph 4, where Vision says that, you know, the second, the BRPs have identified 2 critical issues that must be resolved to avert THL's liquidation. The first is securing the urgent funding required by THL to continue trading in business rescue. The BRPs quantified this requirement at 600 million rand. The second is finalizing the implementation of a viable plan,
Why is there so much of shuffling in this court? Please, I'm trying to hear counsel. Yes.
including the refinancing of the post-commencement finance facility. Now, my lady, a lot of things in this case are said but not explained. This all goes back to the fact that Vision does not have money to implement its own plan. It needs, in order to close the business rescue proceedings, it needs the IDC to fund it in full. And your ladyship will, in due course, I'm sure, read what Vision says in this affidavit, but what I wanted to show your ladyship was at paragraph 12, where Vision says that the IDC states that it is amenable to engage without delay and states that it recognizes the urgency in arriving at this resolution. However, the IDC's conduct has not matched its assurances. Despite Vision's repeated approaches, the IDC has not engaged constructively with Vision on THL's future prospects. So what Vision does in this affidavit is it draws a distinction to the granting of the additional 200 million in PCF, and then it focuses on the future prospects being the IDC's capitulation to Vision's demands for funding in excess of 5 billion rand. They proceed then to say, this concern was set out in the letter from Steinscop attorneys to Worksmans on the 8th of April, a copy of which was attached to the IDC supplementary affidavit. And this is what I wanted to show your ladyship. The IDC states that it is amenable to any viable restructuring, in inverted commas, but does not even mention the proposals made by Vision. It remains unclear to Vision whether the IDC is committed to a plan with Vision, underlined. The upshot of all of this is that while there is agreement for 200 million rand, there is not one smidge, not one iota, not 1 millimeter of progress that has been made in addressing the fundamental obstacles to implementation that the BRPs themselves relied on expressly to motivate for a liquidation order being granted today. My point is that liquidation is clearly unwarranted on the facts, but that the Section 141(3) application cannot just be pushed into a 3-month loop, to use the BRP's words, of hope. The fact is that they haven't made out a case for the relief they seek.
Yes.
Milady, it goes even further, because the BRPs have admitted that they were implementing unlawful conditions that were asserted by Vision, which
Where do you get that from, Mr. Kotze?
the BRPs.
Why would they be admitting that they're implementing unlawful conditions?
Lady, it's in the founding affidavit. Can I take you to RGS's heads of argument, please? So the 2 conditions were that the IDC fund Vision fully, and the second is this broad-ranging legislative and structural reform of the entire sugar industry. Those are the unlawful conditions. So if I can refer your ladyship to paragraph 31 of my heads of argument.
Yes.
So at paragraph 31, I list the facts that are revealed by the IDC and by the BRPs in this application for the very first time. My lady, I can say that it is impossible to conduct a thought exercise to explain the difference between this information that was provided and what affected persons knew at the time, what they knew contemporaneously, because nothing was disclosed transparently. And that is the point that the Minister for Trade and Industry makes in his supplementary heads of argument. So when one reads these allegations, one must understand that they are being made for the first time in the context of this application and were not communicated at all to anybody. They were confined to the knowledge of the business rescue practitioners and or the Vision and the IDC. But my lady, can I take your ladyship to paragraph 31.7, because that is really the one that I want to show your ladyship. Paragraph 31.7 of my heads of argument. So the BRPs say in their replying affidavit that Vision imposed conditions not contained in the adopted plan. In amplification, Vision demanded an in-principle reform to the sugar industry and its legislative framework. A requirement that was not contained in the plan, was outside the control of the BRPs, and as stated in the founding affidavit, caused nothing but further complications and delays. Moreover, Vision required not a mere refinancing of the PCF facility, but a much larger IDC facility which contained an onerous debt-to-equity conversion and write-off features which were unacceptable to the IDC and which led to the breakdown of negotiations. Those are the same negotiations in consideration today, my lady. Then the BRPs conclude that Vision's imposition of conditions not contemplated by the adopted plan is conduct inconsistent with the binding terms of the plan that Vision itself proposed. This is why, my lady, at paragraph, in the following paragraphs, I explain the import of that. But where this all lands is at paragraph 35 of my heads of argument, where I refer to the authority of the Supreme Court of Appeal in Vantage Goldfields. And I refer to the judgment of the High Court in Limbourus. The authority in Vantage Goldfields is that even where a business rescue plan contains a provision purportedly permitting business rescue practitioners to make unilateral amendments to plans post-adoption, that is not permitted, because the court held, in terms of the Companies Act and Section 1524 and all of the sections that say once a plan is adopted, it binds everybody. It binds the creditors, the employees, the shareholders, and the BRPs. And the SCA said that the practitioners can only implement the plan as adopted, strictly in terms of its own provisions. And the SCA endorsed the findings of the High Court below that were to the effect that a change of the funding of the plan goes into the heart of seeking to resuscitate a distressed company, and that the ability and credibility of such a funder is everything which the creditors of the distressed company, including affected persons, would want to know and be sure of. So what the BRPs say in their own founding affidavit here is that not only did Vision impose conditions extraneous to the plan, because the plan, your ladyship will recall, is not premised on any funding being obtained by Vision, not a single cent. Your ladyship can search the assumptions and conditions contained in the plan to no end. There's no disclosure that the implementation of the Vision plan is conditional on a single cent of financing being obtained by Vision. Secondly, there is most definitely no condition in the plan that Vision requires a wholesale reform of the national sugar industry from a structural and legislative perspective. On the BRPs, your ladyship need not take my word for it. The BRPs say to this court in their founding affidavit that those conditions are not contemplated and extraneous to the plan. So on the authority of Vantage Goldfields, it was unlawful for the BRPs to implement the plan according to those terms. But not only, milady, did they proceed to implement, as Vision says in its answering affidavit to the counter application, the BRPs went out to bat for Vision. The BRPs write to the IDC. They say, we need the structural reform. We need all of this money for Vision. We need this financing. So they go, they say, yes, these conditions are extraneous to the plan. Creditors didn't know they existed. Creditors didn't vote on them. But let's go and try and enforce and apply them on Vision's behalf.
Yes.
So my lady, to keep this application alive and to keep the plan alive would be to perpetuate that unlawfulness and to leave that unlawful conduct unchecked. And I would re-emphasize the decision in Limboris where the court held that for all of the protection that business rescue proceedings and business rescue plans enjoy, where a plan is unlawful, where it's not implemented according to its own terms, it should be set aside. It should not enjoy any protections where it's not implemented lawfully. Milady, so reaching the conclusion, and sorry, Milady, that is Limboris at paragraph 50. I'm sorry, I don't have I don't have the reference to the joint bundle page number, but it's the judgment of Limboris at paragraph 50, and it's also Limboris at paragraphs 86 and 87. So my lady,
86 and 87?
Yes.
Yes.
Sorry, 86.6 and 86.7. So, milady, I sympathize entirely with the inclination to adopt a pragmatic approach today, but the law cannot be ignored in relation to the manifest non-compliances that have been manifest in the plan and its implementation. Lady, I understand that the IDC is of the view that the postponement of this application and the continuation of the Vision plan will allow other parties, not only Vision, to make renewed proposals. But, my lady, that view is contrary, to the best of my understanding, to the established legal position that an adopted plan is binding on all parties for so long as it remains in place. And conveniently, the authority for that is also in Vantage Goldfields, where the court cites the previous SCA decision in Kransfontein, as well as in Limboris in the paragraphs I've already mentioned to your ladyship. So in other words, as long as there's a plan that has been adopted and it hasn't been set aside, it applies to the exclusion of everything else. And as a matter of fact, as is evident from RGS's affidavit in this matter, every proposal that RGS has made to the BRPs has been refused by the BRPs expressly on the basis.
Mr. Kotsa, I must stop you there. I understood your purpose for addressing me is to address me as to why the application for liquidation should be dismissed and not postponed. You are now venturing into the realm of arguing the entire application. I haven't made any ruling as to whether the application must be dismissed or postponed. The purpose of your address to me was whether or not the matter ought to be postponed.
Lady, as I understand
because what
it,
you are now attempting to do is address me on the entire matter.
my lady, that is not my intention. It depends on what my learned friends seek in terms of this postponement. If postponing the liquidation application means that it is then confined to the Vision plan, then that's one scenario. If I'm told, which I have been led to believe, that what they seek by this postponement is a situation where any third party who wishes to submit a new business rescue plan may do so, that's a different position. So that needs to be confirmed. But to the extent that I understand the law, As soon as your ladyship postpones this application, it means that the only plan that remains in place is the unlawful vision plan. So to the best of my understanding of the law, it follows from that it would keep the vision plan in place to the exclusion of any other possible proposal to try and save THL. And for that reason, to the best of my understanding, it is relevant to the question of postponement versus dismissal of liquidation today. And I mention it not, with all due respect, my lady, to try and sneak in argument on the merits. It's simply because the IDC, my understanding of the IDC's position is that they understand the postponement they seek will enable all people who want to come to the table with new proposals to do so. But my understanding of the law is to the contrary. So I think it is central to the question of postponement, and I needed to ventilate it, my lady, but that was literally my last submission.
Yes, thank you, Mr.
As it pleases.
Mr. Allsworth?
Yes, Lady, just briefly, the intervening shareholders largely align themselves with the arguments made by RGS, but that being said, don't necessarily have a preference for whether the application should be dismissed or postponed, but there are some points that I want to highlight on that topic. Now, firstly, as Mr. Kurtz has said, the issuing of a liquidation application has quite significant consequences. And my lady, that is exactly the reason why the practice in this division is that you cannot adjourn liquidation applications sine die. So if the matter is to be adjourned, then perhaps consideration must be given to adjourning it to a specific date to ensure that it can't drag out ad infinitum. And lady, we also need to consider the context in which the application is brought. This is not an application brought by a creditor alleging a debt and an inability to pay the debt. This is an application brought in terms of Section 1412 of the Companies Act. And Section 1413, in the context of such an application, gives the court quite wide powers in respect of what orders it can make. Now, the essence of the application, putting all else aside, is largely this. The company finds itself in a position, and the business rescue practitioners find themselves in a position where the company simply cannot finance its ongoing operations. Now, the reason that we are given today for the need to postpone the matter is that this additional funding has become available, which will allow it to continue its operations for several months to come. But the question at a practical level, my lady, is this. What do the business rescue practitioners actually do for the next few months? They have the funding to continue the business rescue operation, to continue the business operations of THL. But what happens with regards to actually advancing the business rescue process to finality?
Yes.
Everyone agrees that the adopted plan in place is incapable of implementation. It's effectively fallen by the wayside, practically, but not legally. As Mr. Kotze has said, regardless of whether it can or cannot be implemented, and obviously it cannot, the fact of the matter is that it remains the approved plan until such time as it's set aside.
Yes, Mr. Allsworth?
There has to be some direction given, lady, for the sake of advancing the business rescue process to some point of finality. So, essentially, my lady, my submission is that if there is to be a postponement of the application, or if there is to be a dismissal of the liquidation application, in either event, the court, in my respectful submission, should issue further directions in addition to that order, in accordance with its power under Section 1413, which deal with how the business rescue process is to continue going forward. And first amongst those directions, my lady, I would think would be an order declaring the failure or the setting aside of the adopted plan. A direction to the business rescue practitioners to receive and consider alternative proposals for an alternative plan.
Yes.
And to publish an alternative plan or an amended plan or whatever terminology you want to apply to it, a further plan to be voted on by creditors at a meeting of creditors in due course. Because absent that, my lady, absent any direction to that effect, the application is either adjourned or it's dismissed. Either way, the consequence is the same. The business rescue continues. The business rescue practitioners continue to trade the business. But how does the business rescue process advance to any degree of finality?
Yes.
And that is effectively our submissions. my lady.
Yes, thank you, Mr. Allsworth. Mrs. Judith?
Thank you, Milady. Maybe just to place on record that we are not obviously involved in the engagement relating to the addendums which was concluded between the IDC, the vision parties, and the BRPs. So effectively, we are not subject to that. In fact, just we are given an opportunity to look at it shortly before court actually commenced.
Yes.
The difficulty we have is Milady has regard to the document. Milady will see that it makes no sense to read the document unless you're reading it against the original document, where the amendments are affected. So insofar as that amendment is concerned, I can't in any way make any sort of meaningful submission to Milady because we are not in possession of the other 10 addendums that were prior.
Yes.
But to the extent that is, we, as far as we are concerned as a freedom, the position simply is this, Milady. The parties have complicated the matter unnecessarily. Milady is dealing with an application in terms of section 141(2). And it is clear, and the BRPs throughout the application have clearly indicated that their hands are tied. They have to come to court to bring this application. Once they reach the conclusion, the company can no longer be rescued. Now, and on their papers they said they can ask the court for nothing else but for that relief. And in fact, they come to court and the matter is then in the hands of the court to make a determination as to what happens with the company itself.
Yes.
Now, this application was brought in February when apparently they arrived at the conclusion that the company could no longer be rescued. Now, Milady will see throughout the papers that much of the parties have said the company is capable of being rescued, and obviously Abrina is one of those parties that makes those submissions and supports that contention. What has now happened is it seems that they've gone from a stance of having the conclusion that it cannot be rescued. They're now saying that it can be rescued. Let's just see what happens in the next couple of months. Now, the difficulty with that, Milady, it means that they no longer hold the conclusion, which is the jurisdictional requirement of section 141(2). In other words, you come to court and you ask the court, based on that, to terminate or to discontinue the business rescue proceedings based on the fact that you as a BRP have come to a conclusion after conducting your investigation, the company can no longer be rescued. Now, Milady has indicated perhaps what the parties can then do is file further affidavits. But where does that then take the matter? Because as of February, they had apparently reached the conclusion the company could not be rescued. Now, after consultation with IDC and division parties, they've now arrived, they've approbated and reprobated. They've now arrived at the conclusion, well, it can be rescued. I'm not seeking that relief today. Now, they've changed their mind effectively. Now, with respect, they cannot come on an adjourned date and say to Milady, as we sit before Milady, that, well, you seek to rely on our earlier conclusion, which you made in February, to be the starting point of when we believe this company was not able to be saved. Now, I'm fully in alignment with my learned friend, RGS, who indicated the difficulty about the fact that the concursus has already been established. And the effect of that must not be lost on Milady. The fact that that was established as when the application was effectively presented to court, that will affect any sort of transaction happening thereafter. Now, with respect, the applicants and the VRPs can't have their cake and eat it, effectively. We have maintained throughout the papers, and Lady will see throughout the papers, and I believe some of the other parties have also mentioned it in the papers, this is effectively just a shotgun approach to force IDC to provide funding. And exactly what they have anticipated has happened at the doors of the court today. Because facing the prospects of having an entity like Tongaat Hulett, which has been around for many, many, many years and has been supported by the community, provides employment to many people, the IDC has capitulated at the doors of the court to provide this fund. Now, bearing in mind that Malay will have seen the papers to what the earlier requirements were as to providing this further funding, and now they've effectively retracted on that in order to capitulate to public.
Well, should I penalize them for that?
Well, Malay, to the extent that maybe they're entitled to do so. The difficulty one now has is they've now arrived at the conclusion that it can be saved. Now the entitlement to rely upon section 141(2) at this stage.
Are you now arguing about the BRPs, not about IDC? Because IDC didn't reach any
Really, I've got no difficulty with IDC making any decision to provide funding. I've got no difficulty with that. I've got no difficulty with the fact that they may have entered into this agreement. My difficulty is this application has been brought before Malady, was brought on an urgent basis. All the parties that have been brought to an urgent basis because they have reached the conclusion as of February that this company cannot be rescued. And that is what the application is premised on. This matter is now adjourned to some date after June. They can no longer rely on a conclusion they had arrived at February with respect. They can't now try and supplement their papers to try and work backwards to say to the court, well, I want you to rely on what I said on February, even though I gave it a further opportunity. What we're simply saying is, Malady, it doesn't end for the BRPs. If they form the conclusion down the line that this company cannot be rescued, they must do it on a fresh set of papers. The base upon which this application has been brought before Malady no longer exists. Because by virtue of them having concluded that agreement and now deciding that they wish to adjourn the matter and not proceed to seek the termination of the business rescue process and seek liquidation, means that they now believe the company can be rescued. If that is the case, the application in terms of 141(2) now falls away. They're entitled to bring a fresh application. What we are saying is the proper forum, the proper form to be taken is for them to withdraw the application and to pay the wasted costs occasioned by that application. There are many parties that have been brought to court on an urgent basis. Malady, that's the only way that this matter can be properly dealt. There's no purpose in adjourning it because Malady, if Malady adjourns the matter will come back before Malady. They'll find further affidavits about what is the purpose of those affidavits, talk about events that came after they had already formed the conclusion the company is no longer able to be rescued in terms of section 141(2), which is the jurisdictional requirement. Cannot put Humpty Dumpty together again with respect. The proper way the matter must be dealt with is that they must withdraw the application, and Malady must dismiss the application because well, Malady, the 200 million that we propose is effectively just working capital for a couple of months. It's not going to change with respect their conclusion in any way. The fact that they've agreed not to seek that relief, Malady, with respect means that they believe the company is capable of being rescued. There's no purpose for this application continuing. They must bring it afresh. That's collectively what the position for bringing it.
Yes, thank you.
Malady,
No.
Mr. Subel and I are having jockeying rights to who's going to speak first and last, but I think I should speak for Vision, Mr. Fine should speak for IDC, and they're the applicant, they should reply and deal with everybody, and I think that's the way to do it.
Yes.
Malady, having listened with interest to what my learned friends have to say, might I just, perhaps if I can, remind the court of a couple of home truths in this matter, and from the provision, and I'm going to do so in a manner, Malady, where I must place on record, there are many things said by Mr. Kotze that we don't agree with, and you said yourself is veering onto the merits. I'm not going to try to respond to the merits.
No,
we're dealing
I
with
don't want you to.
we're dealing with an application for a postponement.
Yes.
There are some legal issues that have just been conflated or thrown in which are just wrong, and I'm going to speak to Adina on that as well. The structure of this company is such that there are two funders or two parties that have interest in seeing this company survive. When I say interest, direct skin in the game. There's the IDC, which has provided PCF funding, and there is Vision, which has acquired claims that puts it at the moment prima facie, despite any disputes, a secured creditor with 75% of the vote. So it can block and pass any plan. Those are the facts on the ground, undisputed for present purposes. Nothing can happen in this company unless Vision, the IDC, and the BRP is on the same page, and that is what's happened now. Where we differ, milady, between us and the BRPs and the IDC is whether we are going to get to a true rescue by June. What the smaller parties say, those who say they've been shunned, and I'll deal with each of them, and they haven't been party to this, I don't see anyone else arriving here with a checkbook today to say, okay, you must dismiss the application. You've now got 200 million in. We know that. Let's not debate whether the plan's failed, whether the counter application should be heard. I'll deal with that. We know that plan is not being implemented. Assume that Mr. Kutz is right, that maybe his client may or may not be able to put in a competing plan. That's the purpose of his counter application. The question is whether it has to be heard today. That's what we're discussing. We're not discussing.
That was what I wanted to be addressed on.
Yes, and so here's why it doesn't have to be heard today. Despite the Turks, let me just say, the Turks are shareholders. The Turks are shareholders who voted against the conversion. They don't even have an indirect interest in any plan. There's no prospect shareholders are going to get anything. I don't even know why they're here. To support RGS, it makes no difference to the Turks what happens here. Shareholders can never get anything. They voted the plan down. For the Turks to say to a court without an application or notice of motion that you must impose conditions on the parties and to how to do this and how to do that, that's why you've got a business rescue practitioner. Let's deal with RGS.
It's not for this court to exercise any
unless you're obviously of the opinion that this company is incapable of rescue, in which case you must liquidate. But no one wants that. You can't come and say the company's financially distressed. I want to bring my own plan. Adina says it's terrible. It's all very terrible. We weren't told. We accept it's financially distressed. Don't give them the further lifeline for 3 months, knowing that that is not the test. The test in 141.2, and Mr. Subu will address you on, you can only dismiss this application if there's no longer if the company now has a reasonable prospect of being rescued. Where's that plan? RGS says they haven't been able to bring a plan. They've also failed about 6 or 7 times trying to interdict the main plan. It's carrying on. Whether it carries on or not, he'll get his day. The RGS counter application, can I take you to it? Snatching at a bargain. The RGS's counter application, can I read it to you? 080-3. Here's the notice of motion. Firstly, they say it's urgent, right? They say paragraph 3. This is RGS.
Yes.
This is before Mr. Kotze found out that it doesn't suit him not to argue today, but it suited him to argue this altogether before the 200 million. Let's go to paragraph 3 at 080-3. That the counter application, that the application brought by the first to third respondents under the above case number for the termination of the business rescue and the granting of a provisional liquid order be dismissed. Now that's the order that he's seeking today. And he's trying to impose on you that you have to give it today, and so is Adina for some reason, and so is the Turks, not quite sure. They're saying, well, maybe you can, but you've got to impose other conditions. So he wants to bring this application. Now, can we just stop there? If one is opposing a liquidation application, do you have to bring a counter application to have it dismissed? No. He could have just filed an answering
Ask for an
affidavit.
outright dismissal.
Just yes, so
filing
yeah.
your answering affidavit.
Filing your answering affidavit and so on. You don't have to. So why? Because it all hinges on the next set of prayers, the ones that he started to argue, even though he said he wasn't. That the business rescue plan is declared unlawful and set aside. That's what RGS want. Final relief, that they must produce agreements. Well, this is the agreements, so they can inspect the agreements to check our security and our debt that the lender group had, that no one has ever contested except them. Then look at that and decide whether they should formulate their own plan once they get that relief, and then decide. This company can't survive. It is a very simple question for your ladyship. Are you satisfied with the bona fides of the business rescue practitioner, the 75% claimant, and the IDC, who all tell you there's a prospect that we can get this company across the line and avoid the liquidation, but we need until June to get it. If June isn't enough, that's a fight for another day. What you don't need to hear now is an application that says dismiss. His prayer for setting aside flows on a dismissal. If you postpone the matter because of the application dismissal, you don't grant the dismissal, you say that no, it should be postponed, then his own prayer says he will argue the setting aside. Then there's no interim. Their complaint is, and the Turks' complaint is that, but in the interim, no one else can propose a plan. They can do what they want. Whether the practitioners are going to rebuff it, that has been in existence for months. Where's the urgent application brought by RGS or anyone else to consider an alternative plan? The
With
urgent,
or without the winding up application
Yes.
having been brought.
yes, that's what started this. The commanders of the winding up application, the dominus litis of the BRPs, they're telling a court, I've got a runway until June, and I'll let you know whether we can do anything with it. It's through RGS or someone else to rescue fully. No one wants this company to be wound up. That's what's unusual about this case. But to dismiss the application, what you're really then saying to the practitioners is, even though you've told me on oath that there's no full plan, and even though you've told me on oath that you're prepared to accept, at least from the bar, you're prepared to accept interim funding, and you as the practitioner believe that that is enough to see whether the company can finally be rescued, that is perfect grounds for a postponement. There's nothing inconsistent with saying, I'm accepting a runway for 3 months, but it's only for 3 months, and saying, but I don't yet have satisfaction that the company can be rescued, because that's the test. What was been argued by my learned friend for RGS and for Dina is that once you accept that you've got 3 months of runway, you accept that there's no longer need for liquidation. It's a non sequitur. The test in 141 and 2 is, does the practitioners now believe the company has a prospect of success? He's telling you, I can't tell you. I've got a bit more time to trade. I will know by June. And that's all we're asking for. And the IDC, the party who's been castigated here as, shakedowns, and we aren't prepared to put in money. My learned friend's going beyond the affidavit. He doesn't know how much money Vision's got, how much money Vision's prepared to put in. Whether or not Vision has imposed unlawful conditions or these things were surprises to it are matters that are going to be dealt with in negotiation between the three parties that really count. And either we come to court with a revised plan, and then my learned friend will argue his counter application, and he'll say the revised plan's invalid because the original plan's invalid. You must jurisdictionally decide today whether there's been unlawful implementation of a plan, whether it's competent to revive this plan that's failed. If the other, this is not for you with respect today. Today is a simple question. The company's been given a lifeline till June. If in June there's another plan, Vision will be able to say it's unlawful, and you'll make a decision. If in June there's no other plan, and the business registry practitioner says, I've got no choice, I can't come to a conclusion, I must proceed with winding up. But to deprive the three main stakeholders of an opportunity now that they are engaging, and you've seen there have been complaints in the affidavits by Vision, you've seen, milady, of the IDC
Yes.
not engaging. We are now engaging. The affidavit that my learned friend referred to says that we have certain obstacles. We would have preferred a clearer path forward. That's what I said to you this morning. We don't yet have it. But we want to give this company a chance to survive. Let's look at the contrary, which is what they want. They want a dismissal of their application. So this court must decide that, contrary to the professional opinion of a business rescue practitioner, who says it can wait until June, but I want to do something to try to save it, you must decide, no, you can't have that. I'm going to finally decide now that there's actually a reasonable prospect of rescuing the company, even though he's telling you he doesn't know. I'm going to dismiss the application, then bring it again later in June, start the whole thing again. The company can't survive that degree of uncertainty. And the final point to be made is this thing about 348 and invalidity. In every application for liquidation, 348 looms large, and the longer it takes, there's a period of time. In other words, if a liquidation order is ultimately granted, then it antedates to when the application was brought. And prima facie says that transactions between that are void. What they're not telling you is that they can be validated by a court, and it's only when they're challenged. If those transactions in the ordinary course of business, they get saved every time. It's not just that everything magically has to be repaid. That's something that the practitioners are aware could be a consequence. That applies if there's a liquidation. Well, if there's a liquidation, lady, the least of the problems in this case are whether or not the transactions between the bringing of this application and the granting are void.
Yes.
The real problem is what happens to the community in the context of a liquidation filing. So you have a discretion to grant a postponement.
Yes.
There is nothing, it's not an appealable judgment. I'm not saying because they will. There is nothing in this case by June that is going to change from RGS's
Mr. Blow,
position.
I
Yes.
will do what is just and equitable. because
Exactly.
That much.
That much,
This court
yeah.
has the power
And
to
it
do.
seems to me that in drawing the balance, it must weigh heavily, in fact, if a petitioner is saying, I've now got runway till June, I've got Vision and the IDCF on board to June. I just want to make clear something, correct something my learned friend Mr. Fine said. The agreement deals with its duration. We don't have to debate with you whether it's October or June. The agreement has its own runway, and it's June, 30th of June. The parties can extend it, the parties can do what they want. But in the interim, we would ask you not to accede to calls from the side to dismiss the application, not to accede to calls from the side, to set aside the vision plan when that can be argued just as easily in June.
Yes.
And we will ask you then to accede to the BRP's request for a postponement with cost reserved. We're happy to have it to a particular date that is arranged with you.
Yes, thank you, Mr. Blow. Mr. Fan, 10 minutes to go before the long adjournment.
I'm going to wrap it up quickly.
Yes,
No.
but I'm not cutting you out
Yeah.
because I still have
No.
to hear after the long
Milady,
adjournment from Mr. Subo.
Just, we, from the IDC's perspective, you've seen our heads of argument in the main application. We have challenged them. We have challenged them on all scores in relation to bringing the application and that they could bona fide form the view. But what we also did say, and we have said in the correspondence, is that given time, we believe that an accord could be reached, and it's a misconception, with great respect, to suggest, and I'll get to read you the correspondence, I need just a short, to take you through that. We are not married to vision, we're not bound to vision. We're not bound to the vision plan, as has been repeatedly stated everywhere, and I'll take you to the correspondence. Obviously, it is recognized that vision is an important player. It has put up the plan and it's got claims. But the IDC have made it patently clear that they will engage with anyone who is prepared to come to the rescue of this company. It's a substantial player in this in this business rescue plan. It has advanced an amount of 2.4 billion. It had taken over the burden of the original lenders with 900 million. It has provided a guarantee to Vision to enable it to pay the lenders of 1.3 billion. And it has also an overriding public interest policy in the sense of the role it plays as a creature of statute obliged to facilitate
And
job
isn't
growth.
that the primary aspect?
Yes. But also within the confines of good business
Yes.
governance. So we have not accepted for one moment the criticism of the BRPs. That's a matter which will be dealt with at a later date. And we will also deal with the vision criticisms if and when the issue arises. So in our heads of argument, and I must make that quite clear to your ladyship, our preferred, after castigating and drawing swords with the litigants, which seems that there's been some rapprochement now, our preferred route, we said that there was no basis for the application for liquidation and that it should be dismissed with costs, but that a period, you'll see at the end of our heads, should be afforded under Section 1413 to allow the parties to try and reach some accord in relation to the rescue. So that is our preferred route, and I'm going to leave that in your ladyship's discretion. You've heard all the parties. But what I should draw to your ladyship's attention is the record at the letter at page 007607, which is Annexure IDC 6, and is dated the 22nd of February 2026, which was the conciliatory approach. And what was said there, my lady, if you could just turn that up for a moment, 007607, is that, and this is important to the issue that everyone's raised, paragraph 2, our instructions are to inform your clients of IDC's preference to ensure the continuation of the business rescue proceedings as opposed to liquidation, to enable the development of a revised business plan in the balanced interest of all steps to ensure that it remains under business rescue. And then the response was, thank you for the conciliatory approach, but we are not prepared to withdraw the business rescue. So whilst we say that's our preferred route, that you dismiss the application or withdraw it, we have made the funding available, and that is a matter for your ladyship's discretion. But we do not accept the contention that vision is, and the reinstatement, and I must make that clear, that the reinstatement of the vision plan is the only way forward. We will engage and as we expect the business rescue practitioners to engage with anyone that makes a viable offer. And lady, it is absolutely important to understand, and I don't want to repeat myself because it doesn't get better the more times, but it's interest, the skin in the game of 2.4 billion rand is substantial. And it must be at large to engage with anyone with the concurrence of the BRPs and other stakeholders who can achieve A, public funds, which have been made available,
Yes.
and B, the obvious overriding interest of rescuing this company. Everybody is at idiom that the consequences of liquidation would be cataclysmic. That's the one thing that all parties are concerned about. Our complaint is the business rescue practitioners didn't give sufficient to that. That's a debate for another day. And our contention is now the money has, it can't be clearer that this money has been advanced with the position, with what we put colloquially as breathing oxygen into the company for the purposes of allowing parties to reach a court. If they don't reach a court, well, so be it. So, as I say, in our heads we said we want dismissal, but I leave that to you.
Yes. Thank you, Mr. Fine. Mr. Silver, should we take the long adjournment and resume at 2 p.m.? I'm assuming you'll be on your feet for a while.
Thank you.
Yes. Court will take the long adjournment and resume at 2 o'clock. Court will rise.
Everyone to say, well, yes, we think it should be adjourned, but no, we don't.
No, what do you want?
That was a new position. That was like, so we don't mind if you dismiss it.
The good position is dismissal. I understand that.
Like you said at the beginning, it said this matter should be
It says,
adjourned.
but we're supporting the vision plan. So, which one?
Stop it. Stop it. Stop it. Do you want a transcript? I'll give you one now. Look. You're about to get a transcript.
You haven't answered to the question of what the business rescue practitioners do after today, and the only one who wanted is an That's the point. The plan has to be clear. It's inside and it has to be put to a present setting. And how can you do that when there's an existing plan? Then maybe, what if they conclude that it isn't capable of amendment and a new plan has to be set? Do that with
it. 1 2 1 2 1 2 raise on it. He rise, he rise.
proposed draft order.
Yes.
We have circulated it amongst the other parties. May I hand it to your ladyship?
Yes, you may.
We've left blank various dates.
Yes.
So we need to populate that once we have an idea, if we can, of a hearing date, and we'll work backwards and insert the date for the exchange.
Now, before you address me, Mr. Sobel, what you're proposing in paragraph 1 is not as a holding date, but for the matter to be heard as an opposed motion.
Correct.
Yes.
In other words, as it were today, duly
Yes.
supplemented.
Yes, you may proceed.
you.
Thank you.
Thank you. My lady, at the outset, there's a unfortunate impression sought to be created by those opposing what we seek today, to somehow attribute some sort of self-interest to the BRPs. And we need to dispel that with respect. The BRPs are officers of the court. They have fiduciary obligations, stepping into the shoes of directors, to act in the best interests of the company and obviously the stakeholders. And that's precisely what the BRPs have done their utmost to achieve. What was sought in the substantive relief in the main application is an order in terms of, well, let me go back, twofold. One is discharging a statutory obligation to report to your ladyship, the court, under section 141(2)(a)(1). And that's an obligation, it's peremptory. Once the BRPs had concluded that there's no reasonable prospect for the company to be rescued, and your ladyship knows what the meaning of rescue is,
Yes.
the Oak Dean 2 type situation. But once they concluded that they were under an obligation to inform the court of that and all affected parties, that's what they did. There can never be a criticism, and it's suggested today that there was undue urgency. With respect, they did what they needed to do when they needed to do. So for the purposes of reporting to your ladyship, with respect, they were under an obligation and they did so. What it also requires in terms of section 141(2)(a)(2) is that they must apply, again it's obligatory, to the court for an order discontinuing the business rescue and placing the company into liquidation. That's the stark choice that the BRPs have. It's not open to them to become more inventive or creative. Either they're going to rescue in the legal sense, as is defined in 128 and 129, or if they believe there's no reasonable prospect of that, they are obliged, as they have done, to approach your ladyship for an order placing the company in liquidation. The suggestion that there's some sort of improper motive, purpose behind the application for liquidation with respect is an entirely unsound one, and the business rescue practitioners, if anything, have the interests of the company, but also statutory obligations to do what they're doing. So we're here today before your ladyship because there's an obligation to be here. Section 141(3) then provides what your ladyship then would do with it. So now faced with such a notification from the BRPs, faced with an application that's compulsory, your ladyship has various choices. And your ladyship indicated to, I think I'll learn from Mr. Blow, that you do what is just and equitable. With respect, that's precisely what 141(3) contemplates. So once there is this compulsory application, the court may make the order applied for, i.e. terminate business rescue and place under winding up, or any other order that the court considers appropriate in the circumstances. So what we're faced with today in this application is your ladyship's discretion. And it's no question of seeking an indulgence to postpone this matter. We must disabuse our minds with respect of any notion that we're seeking an indulgence. I heard today argued that postponements aren't there for the taking. This isn't that sort of matter. This is a matter where under 141 the BRPs did what they were required to do, and then with respect it's up to the court on everything before your ladyship to make an order that you consider appropriate in the circumstances. The relief that's sought in the main application is the only order that the BRPs can apply for under 141(2)(a) Roman 2. That doesn't mean it's the only order that can be granted, because 141(3) then vests with respect in your ladyship the discretion to make such order as you consider appropriate. And for that reason, perhaps, if I may suggest, what are the three orders that your ladyship could make today as appropriate? The one order would be today to refuse to defer the decision in this matter and to grant the relief. In other words, terminate business rescue and place the company into liquidation. That is one option open to you. We know what the consequences of that would be, but ultimately it's for your ladyship to weigh up.
That is common cause on the papers, in fact.
Absolutely.
Yes.
So that would be the one option, which doesn't appear to be particularly attractive. The second option is to dismiss the application, but that would require that your ladyship disagrees. You were to find then that you disagree with the view, the conclusion reached by the BRPs under 141(2), that there's no reasonable prospect for the company to be rescued. On the papers in the founding affidavit, up until today, with respect, we submit that would be the inescapable conclusion. And that would mean, because we know that there's a plan that's failed, whether it's ceased to have any effect is a different issue, but an implementation that's failed. Your ladyship is aware that under the Act, business rescues contemplated should be 3 months. We're now 3.5 years.
Yes.
It took 14 months to develop this vision plan, and there's no other plan on the horizon. It's all very well to hear RGS talking about an opportunity that they're seeking.
Well, apart from the opportunity, Mr. Sugul, what do you also say about the submissions advanced by counsel for RGS that the vision plan has failed and therefore this court must set it aside?
Yes. So
because that was
central.
Most of the argument.
Correct. So with respect, it's not correct. So what happened is, your ladyship will recall the original plan contemplated one of two scenarios to rescue. Originally, the rescue was both senses under Oakdean. It was to restore to solvency. That would have occurred if the conversion of debt to equity materialized. Because then it would be that you had shareholders, the company would continue in operation, and it was envisaged that it would be rescued in that sense, to be restored to commercial solvency. When the shareholders voted against that, that option seems to have fallen away. But the second option then triggered under the plan, and that was now
So that
sale
was the
of
vote
assets.
in August.
Yes,
When?
August, yes.
Yes.
So that then triggered, and that would really be a structured wind down. And once into that, there's still a rescue. The plan didn't have CPs that have failed. The sale agreements did. And as we understand what occurred with the sales, is those agreements have lapsed because they were the CPs under those agreements were not fulfilled. The plan is still alive. Alena Fremaskotsa refers to Vantage and Okamanzi. What that decision dealt with was the ability of the BRPs to vary the plan. And your ladyship will recall in that case, there was a clause in the BR plan that actually said that the BRPs can, in their discretion, amend the business rescue plan. It was argued and upheld by the SCA that that didn't mean that they could make substantive changes. It was only administrative or minor procedural,
Yes.
and the court, Wendell AJA, understand now to be BJA, with respect found that and the court concurred with this, any amendment of a substantive nature has to go back to the creditors. So get back to your ladyship's question to me. The plan has not failed. The plan is alive, unless and until it's set aside on some other basis. But that will be a debate on another day when we deal with the merits of the account application. But I think we need to get out of our heads that the plan has failed. The transaction for the sale of assets, the second scenario under that plan, has fallen away. Doesn't mean that there can't be other transactions, other forms of sales. So it's very much alive and extant. So the second scenario I was painting, considering your options under 141.3, then is that you were to find that the BRPs are correct in the assessment and grant the order, and that would be liquidation with the consequences we know. The third alternative, and with respect, we can see only two that I've already identified. The third one is for your ladyship under 141.3 to adjourn the matter. And that would be an appropriate order, and we consider the words here. The court considers appropriate in the circumstances. We submit it to be appropriate in these circumstances on the basis of what you know today. You know that there's further funding now being made available, and there is a prospect of avoiding the calamitous consequences that would flow from a liquidation. And the BRPs, with respect most responsibly, have said we're very concerned. If we don't get PCF, post-commencement funding, we have to shut our doors next week. We won't make it through the month. Employees will suffer. Growers will suffer. Suppliers will suffer. Everybody will suffer. And the way to ameliorate that would be, whether it ultimately eventuates in a rescue or not, we can't tell you, but it appears let's give it a further chance. And that's with respect what's before your ladyship today in deciding whether or not to postpone the matter as we request. So we don't presume that postponements are there for the asking. We are submitting that in view of what we've seen between the IDC and Vision, particularly culminating this morning while we're standing down, and the conclusion of these further agreements, we submit as the BRPs that it would be appropriate to give us a further chance. And that's the only option.
Sorry, Mr. Sobel, I must put to you what are the submissions then made by Mrs. Deoda, who appears for Abrina, that the BRPs would be approbating, to quote her words, approbating and reprobating, and Humpty Dumpty cannot be put together again.
Yes. So we have a fundamental difficulty with that submission.
Yes.
Firstly, there's no approbation and reprobation. There's not choosing inconsistent remedies, because the application is kept alive. The relief will still be valid unless and until there's a change in circumstances that before the next adjourned date it's demonstrated that it's no longer a situation where there's no reasonable prospect of rescue. So if the circumstances when we return to this court, if the matter were to be adjourned, the circumstances at that point are there is now a reasonable prospect for rescue, well, with respect, that's entirely consistent. And then your ladyship would have the power under 141.3 to do whatever's appropriate at that time. So we, with respect, have great difficulty understanding that submission. And there's no destruction that Humpty Dumpty has fallen off any wall. There's no Humpty Dumpty, there's no wall. It's simply continuing the process. Because up until this morning, the BRP saw this as hopeless.
Yes.
There was no further funding. Now there's hope. And while there's life, there's hope. So we submit with respect of the three scenarios as to what your ladyship should order under 141.3, there is only one viable outcome, and we submit it's the course that we've suggested. And we've suggested it bearing in mind the interests of the stakeholders involved here and the company. I learned from Mr. Kotze with respect contradicts himself in certain fundamental respects. He starts off by submitting to ladyship. He says he hasn't read the documents we ended up this morning. He hadn't had an opportunity. Well, perhaps it would have served him better had he read it, because he made a submission to ladyship that the PCF on offer now, the additional 200 odd million, would be there in any event. If I can take your ladyship, I handed up the document this morning. The first in the...
Please just bear with me.
Thank you.
Yes.
So
Yeah,
in
you're
the
reading
amending
from-
agreement number 11, it
Yes.
should be the first of the documents, at type page 8 of 28. Your ladyship will find an amendment to clause 2.7 of the initial PCF agreement. This is in clause 4.1.5. The availability period of the PCF starts with the financial close and, importantly, ending on the earlier of. So PCF will come to an end on the earlier of one of various dates. And we find in 2.7.4 the date on which an order is granted, setting aside the business rescue plan. That's exactly what they're asking for. So if RGS get the order under 274, the date the order is granted setting aside the business rescue plan, if that's what they get, setting aside the vision plan, that's the end of the availability of PCF. So if they were to continue and argue today, it's actually destructive of the entire case. And while we're on this clause,
I'm sorry, on that point, just so that I understand, if that were to be the case, then IDC would have to consider any PCF afresh.
Well, they don't. They certainly haven't pointed out. The problem here is, yes, so the submission to ladyship was, thank you, this is a gift from the RDC, and they are philanthropists and altruistically are going to contribute 200 million rand, and therefore we can merely go ahead, because their stance here is that they don't want a liquidation, or they argued very forcefully today why it should be liquidated, point I'll get to. They don't want a liquidation, they want to preserve the business rescue. But the first opening submission from Mr. Kotze was, we now got PCF, so why not? We now have the luxury of time, he says, because we can go ahead with the business rescue as it is. You're no longer financially distressed, because you're going to have this gift from the RDC, and we can now, RGS, can now go and formulate our own plan and place that before creditors. The fundamental fallacy in his whole argument is that this PCF today is not going to materialize. And what he cannot answer for your ladyship is what will happen tomorrow or next week or next month if there isn't any further PCF from the RDC. And there's no alternative source of funding that's been suggested. So his argument with respect implodes, because if the postponement were not to be granted and you were to hear and decide in his favour the setting aside of the business rescue plan, well, that's the end of PCF. And with respect, that's a gaping hole in his argument. The other contradiction with respect, fundamental contradiction in his argument, is that he argued very forcefully why this company is in a hopeless position. In fact, listening to him, I thought he was probably making out the case for liquidation. He said it's failed, there's nothing left, And then one asks rhetorically, and yes, and then what? What is now to happen? He doesn't want a winding up. So he says it's insolvent, the plan has failed, there is no plan. And then we ask, yes, and then what? Then what? You stay in business rescue without money. So with respect...
There will be no rescue in that
Well, there'll
case.
be no rescue, that's the end of it. So with respect, the entire substratum to the argument advanced by him with respect fails. While we're on 4 and 5 in the amending agreement, I just also want to point out, apropos what Mr. Fine said, he believed that we should rather have October. That's not available either. 277, the IDC, the earlier, is one of the events is 30 June. So the PCF comes to an end 30 June. We're bound by that. And when we suggested June, it wasn't because we thumbsucked that, it's because we read their agreement. Their agreement which provides for PCF funding up until one of the dates, the earlier one of which is 30 June. Then doing a head count amongst those who are in court today for and against the postponement that we're seeking. So we know Vision is in support, and with respect for good reason. We're not doing their bidding, as has been suggested today. We're doing the bidding of the company and the stakeholders, and the BRPs are concerned that employees and others are not prejudiced more than they need to be. But Vision Plan is the only plan that's eventuated. You will have read, and we won't go into the detail of that, the sorry history that RGS has had in trying to, at every turn, obstruct, prevent that plan from proceeding. But unlike the BRPs, they're not acting selflessly in the interest of the company. RGS is acting in its interests. Its only interest, the self-interest, and its agenda, regardless of the consequences, is that it wishes its plan, if and when that ever materializes, because previously they couldn't come up with funding. There's an allegation of a fraudulent letter that they gave. But these are the stakeholders now, a very minor interest, very little skin in the game, and they're the ones now pontificating, professing to advance the interests of the community and the company, whereas they're doing the exact opposite. It's all about RGS seeking to advance an opportunity, secure an opportunity for it to advance its own plan. And that's why they're so desperate to have an order setting aside the Vision Plan, because they consider, no doubt, the law to be that while there is an adopted plan that is still in the course of implementation, they can't put up a competing plan. And that's why they made the submission that your ladyship put to me earlier for my comment on whether or not the plan had failed. The Vision Plan has not failed. The transactions for the sales have failed. It doesn't mean that the plan's not there, and it doesn't mean that the BRPs cannot go or shouldn't go back to creditors in the event of new sale agreements being concluded. We as the BRPs can't predict at this stage whether there will be new sale agreements that are viable, and if so, what they will be. It's not within our hands. We are reliant, as is the court, on Vision and the IDC here. So I think it's absolutely plain here that RGS must be seen for what it is, and that's acting purely out of self-interest in order to achieve a position where it preserves the business rescue. And that's where, with respect, as I indicated earlier, there's this fundamental contradiction, because they contend that it's insolvent, they contend, in fact the argument was really all about this is hopeless, there is no business rescue plan, and then you're left in a world to ask, and I put it rhetorically earlier, And then what? And then what is, well, keep it in business rescue without a plan, without money, without PCF. We can see where that leads. So we submit with respect that it's an entirely inappropriate opposition that we're facing today from RGS. And those who align themselves, I listened carefully with respect to Abrina's submissions.
And, sorry, Mr. Silver, also the submissions by Mr. Allsworth.
Yes, for the intervening shareholders.
Yes.
He started off by being agnostic and then became more and more partial to the RGS argument. Not quite sure what was attractive to those shareholders in it. But what you didn't hear, you heard what shouldn't happen. What we didn't hear from him is what should happen. The people who are coming to protest today and oppose have not given your ladyship the what should happen. RGS has got halfway there, but with respect, that's something that's completely unworkable, as I've demonstrated. The others, Abrina, intervening shareholders, have nothing of any assistance to this court, nothing useful to contribute to this discussion. And the argument that he also advanced was that your ladyship should now step in and perform a supervisory role, that you should now order steps to be taken to advance the business rescue to finality. His words were directions in order to achieve finality. Again, I pose rhetorically, what? What is your ladyship supposed to direct? We know that there is a plan. There is only one logical direction to give. Let's give this further funding an opportunity, and if by the end of June nothing materializes that evidences an ability to rescue, well, then we'll deal with it at that stage. But unfortunately, Abrina, the intervening shareholders, nobody has given you any assistance as to what should happen, and certainly nothing of that could be regarded as viable. Our learned friend Mr. Kotz also referred to the Faber case, which is authority that the court doesn't have the discretion to extend a failed plan. Well, we don't have any difficulty with that principle. This plan has not failed. As I indicated, it's the second category of transaction, the sale of assets, those have failed. But there's no CP in the plan itself that is not being fulfilled. Our learned friend also then started straying into the debate about an acknowledgement that the BRPs will be implementing in unlawful conditions. And your ladyship asked him where this is. And he went east and west and everywhere else and never answered you. He then took refuge in his heads. And the best he got to in his heads was that the applicants had said Vision had tried now to introduce certain conditions that were outside of and at variance with the plan. And that's a far cry from the BRP saying we're going to implement an unlawful term. So he never got there, and he never with respect answered your ladyship's question. So, my lady, we submit with respect that going back to 141.3, which is really where the debate lies, of the three, we can't think of any other scenarios, but of the three that we've identified, there is only one viable one. If that were not to meet with your ladyship's approval, if your ladyship considered that that's not appropriate, the additional PCF as we see it and an opportunity, then with respect we into one scenario only, and that will be the very, very detrimental winding up. If you bear with me one moment.
Yes, I shall.
Thank you. So, my lady, subject to including dates in the draft order, we had moved for an order in terms of the draft, but we'll need to fix dates. Thank you, my lady.
Yes, thank you. This morning, this matter was set down before me as a special allocation for the hearing of a liquidation application brought by the business rescue practitioners as the applicants in a winding up application, as well as a counter application brought by RGS. From my understanding of the papers as at the time the matter was placed before me, the crux of the complaint and what precipitated the winding up application by the BRPs had been the lack of further funding, without which what is known as the vision business plan could not be implemented. In other words, the vision plan would not be able to proceed further due to lack of funding. 2 days ago, the IDC delivered a supplementary affidavit, and that led to the parties approaching me this morning, advising that they wished to discuss the future conduct of this matter. When the proceedings started this morning, I was presented with a draft order wherein the business rescue practitioners, being the applicants in the main application, sought a draft order that the matter be adjourned together with timelines for the further conduct of the matter. This application for the adjournment was supported by the vision parties, by the IDC, and the South African Cane Growers Association. The Minister of Trade, Industry and Competition also submitted that in context the main application ought to be adjourned. The seeking of the adjournment was, however, opposed by RGS, by the Turks, who seek leave to intervene, and who are shareholders in the entity known as Tongaat Hulett Limited, as well as the entity known as Abrina 9744cc. The basis for the opposition to the adjournment by RGS was that, and what was submitted by counsel was that the vision plan has failed and therefore it must be set aside, and that this court ought to dismiss the winding up application. I also heard submissions from Mr. Allsworth, who appeared for the Turks, and by Abrina, aligning themselves with this position. Section 141(3) allows this court 3 options. One of those options would include an adjournment of the matter in the appropriate circumstances. From a reading of the papers, and certainly what has been common cause on the papers, filed by all the parties, is that it would not be in the interest of all the stakeholders that at this stage Tongaat Hulett which in my view has been the lifeblood of this province, be taken out of business rescue. Certainly, and I agree with the submissions made by Mr. Subel in this regard, what would become of the PCF funding if such an order was to be made, and certainly where then for Tongaat Hulett in the absence of any cogent plan and funding. I am therefore of the view that the winding up application and counter application brought by RGS would or must be adjourned. That, in my view, would be a just and equitable solution to allow for further business rescue to be considered for Tongaat Hulett. I am therefore inclined to grant the order in terms of the draft order. What I propose to do, however, and Mr. Subel, I address this to you, but it is to all the parties, dates and timelines need to be agreed.
Yes.
And perhaps the starting point would be when this court would be available.
Yes, that's what we had in mind. We thought we would work backwards from that date.
Yes, yes.
Thank you.
And I assume it would be sometimes in June, because based on addendum
If that can be
11.
accommodated.
Yes. I will stand this matter down briefly and check up on the dates. I will ask to see counsel in chambers and advise counsel of the date, and thereafter I expect counsel, all of them, sensibly to agree on the further time periods. For now, court will rise. As I indicated earlier on, this matter stood down for the parties and the court to arrange dates for the adjournment of this matter. And court and the parties have agreed that the date in which this matter must, the main application as well as RGS's counter application must stand adjourned to is 17 and 18 June 2026. The costs occasioned by the adjournment will also be reserved for determination in the application and counter application. Subject to those two orders, I grant the further orders set out in paragraphs 3, 4, 5, and 6 of the draft order handed up to me by counsel. I further record that the timelines set out and the date for the adjournment is by consent. I therefore grant an order in terms of paragraphs 1 to 6 inclusive of the draft order, signed and dated by me. Thank you. Court will rise.